contested legislative elections for Congress. And if you look at the their state legislature, it's exactly the same thing. My argument is, look, I can't tell you exactly how to draw the lines in those states, but I can tell you how not to draw them. You're not allowed to draw them in a way that consciously destroys the ability to have a contested election. And that's what I would argue my First Amendment does.
You have a great chapter called Mr. Madison's Neighborhood, and you note that 5 kinds of people live there: speakers, hearers, conduits, and speech targets, and government speech regulators. And you distinguish between the exalted status given to what you call the aristocratic speakers, with the slightly less respect given to the haute bourgeois hearers, and then we're moved down to the arriviste conduits, and toward the bottom, the slum-dwelling targets, and then finally the local motorcycle gang of the government speech regulators. Tell us more about that hierarchy and how you would reconfigure it to give all the groups equal weight.
I did the chapter as a kind of whimsical effort to try to capture the ethos of First Amendment doctrine. So many times when I try to write, when all of us try to write First Amendment work, the doctrine is so complicated, the area is so carefully and beautifully developed by the courts over the years, that we get caught in talking about this tree and that tree, and we lose the whole idea of the forest. And so what I tried is to get on top of the First Amendment and say, what does the speech universe look like? And I called it Mr. Madison's Neighborhood. I'll start at the end, which is the motorcycle gang. We now view any government effort to regulate inside Mr. Madison's neighborhood as an effort by some motorcycle gang that if you give them any traction, they'll trash the neighborhood. They just can't be trusted. No government, and I think, one, there's a good deal of wisdom there. I don't like the idea of the government regulating speech any more than anybody else does. No government's ever gotten its hand on speech and not tried to use it for its own advantage. So there's no quarrel for me that you got to be really nervous about the motorcycle gang. But one of the things you might want to do with the motorcycle gang is take away their guns, or is limit their ability. Don't say they can't regulate at all, but limit their ability. And you might want to think to yourself, are we really right in saying that we cannot trust government to get its hands on anything to do with the intellect? I mean, don't forget, this nation has run a public education system now for almost 150 years. Now, it has its problems. You can't speak in Washington, D.C. and not acknowledge the great difficulty coming out of New York. It's the same, the great difficulty with public education in the inner city, the great difficulty with making it truly equal and giving everybody a fair chance to move up. But the one thing we don't say about public education is that it's been used as a propaganda technique to brainwash kids. By and large, we have trained citizens to be free-thinking citizens in a democracy, and they've come out of the public schools, and they've done that. Now, if the story of the motorcycle gang is true, those schools should have been constant efforts at indoctrination. There shouldn't be a public library in this country that is really worthy of the name. Why? Because the government puts the books in there, and you can't trust the government at all. But of course, that's just totally counterfactual. When you watch the government carefully, and you're suspicious of it, and you make sure they minimize the opportunity to abuse the power, there's no reason to give up on regulation entirely. So much of the free speech is a speech world that's based on, well, of course this is a terrible person, and of course this is bad speech, and of course it's going to have a horrible effect on people. But we can't possibly do anything about it, because if we start down that road, you're going to turn around and Mao Zedong is going to be on our shoulder. The truth is, the road doesn't necessarily go there. It doesn't go there in Britain, it doesn't go there in France, it doesn't go there in Germany, and it doesn't have to go there here. We can regulate for aspirational reasons, to make the system work better, and not be afraid of the boogeyman under the bed. The
part of the deregulatory vision that I think will most engage traditional civil libertarians is the call for taking the hearer's dignity seriously. When the speech impedes a hearer's ability to function as an equal, the court should ask whether the protection is best deployed up front. You say that the Phelps hate speech case and the Congressional Medal of Honor case and the violent video games case might or might not have been wrongly decided and return on the facts, but I want to understand more specifically what kinds of hate speech you would allow the prescription of it. I'll just start with, we had a great podcast debate yesterday with Eugene Bollock and Kent Greenfield on this University of whatever it is, the racist video on the bus of the Oklahoma. Could that be banned on your vision?
I think it could. I think it could. I have to start by saying that when I start talking this way, you will immediately get a telephone call from the ACLU demanding that you return the real Burt Neuborne. Because this is counter ACLU doctrine. Don't forget, I led that legal program. It was one of the proudest things I've ever done, and I still love the organization. But my sense is it's this. That's why I talk about aristocrats and bourgeoisie for a second. When you think about why, take a step back for a second and say, why do we have a First Amendment? The idea that I usually there are three usual reasons that get thrown out there. The marketplace of ideas idea that you want everything circulating so that truth will eventually triumph, which is fine, except truth doesn't always triumph in that situation. But more importantly, we don't really have a free market. If we had a free market, that might be one thing, but we don't have a free market. The powerful always get outgun the weak in the market and ideas. Now, having said that, I believe it's an important metaphor, and I think it's very useful, but it's not a Trumpian metaphor. The metaphor that I find most useful, and that was Holmes's idea, the metaphor that I find most useful is Brandeis's idea. Brandeis said, no, the reason we have a First Amendment is because we care about human dignity. And part of the definition of human dignity is the capacity to express yourself, to say and to realize yourself as a person through the capacity for expression, which we thought then, and it may be wrong, but most of us think now is probably unique to the human species, although we're going to find out that other species communicate as well. But the idea that communication can help build us as individuals, I think is central, and I think that's what's worth fighting for. That's why people fight for the idea. The third idea is we can't trust government. So government mistrust. So those are the three ideas. Now, the problem with our existing law, I think, is that we say the speaker has dignity. The bigots that were demonstrating on the fringe of the funeral of the kid who died in Afghanistan while his family was buried, we say that they have dignity. The guy that lied about getting a Congressional Medal of Honor so he could enhance his local political clout, we say he has dignity. The guys that make animal pornographic movies about crushing small animals, we say they have dignity. The guys that sell violent video games to children, we say they have dignity. And you know what? It's true. They all do have dignity in various categories and amounts, but they're entitled to that dignity. But that's not the whole equation. There are the heroes out there, and guess what? Heroes have dignity too. They have the right to have their humanity respected in some way. Existing First Amendment doctrine stops at the dignity of the speaker and virtually ignores the dignity of the hearer. Now, I'm not sure myself, as someone who really cares about free speech, what I would do when I inject the dignity of the hearer into the system. And I start thinking about it a little more, worrying about it a little more. As Jeff pointed out, those cases then become very fact-specific to me. But I know that the four cases I talked about become harder. They become much harder. The case that haunts me is the case of the family burying their child after having been killed in Afghanistan. And to have these guys have a demonstration, now, out of earshot, they couldn't hear it, because it was on the sidewalk right next to the cemetery, and the cemetery was far enough away, the gravesite was far enough away where they couldn't hear it. But they knew what was going on. It was clear that there was someone out there exulting about the fact that they were burying their child. Maybe we can't have freedom in this country unless we let those guys do that. But it's a question that I want to ask much, much harder than simply saying, "Oh, I have dignity," and that's the end of the question. There's more. The dignity of the kids that go to Oklahoma University, that want to live in a decent educational environment, in which there's a rule that says that no fraternity can discriminate on the basis of race, and that no facility of the University of Oklahoma can be made available solely on the basis of race. The kids, black and white, who want to live in that world, because that's the world where you will have the best kind of education. That's the world where you will genuinely educate people for a democracy. It seems to me that the kids in that world are entitled to some protection against a group of people running essentially a pep rally to violate the rule on racial against racial discrimination, because that's all that was a pep rally, chanting that we're not going to do it, hell no, we're not going to let blacks into this fraternity. Seems to me at that point, if you care about the rule, and then you're going to allow them to have a pep rally that says we're not going to abide by the rule. That strikes me as something that you should be able to deal with, especially on a college campus. Now, I want to distinguish that from discussion of whether that's a good rule, or discussion about whether bans on racial discrimination are a good idea. Obviously, that's clearly protected by the First Amendment. But I'm talking about the pep rally that is designed to generate action. It's designed to make sure that no black kid pledges that fraternity. And it seems to me that for me that crosses the line, and I would have held it to be, and I think the courts would hold it not to be protected.
Can I press you a bit on Brandeis and dignity, because a lot turns on it, namely, are we going to have a more European system that allows for the regulation of hate speech, or the U.S. system where both liberals and conservatives at the moment seem to agree that it can't be regulated? So Neil Richards has a very good new book out called Intellectual Privacy. And he acknowledges that Brandeis, in his original privacy article in the 1890s, was concerned about protecting the dignity of aristocrats against the society papers. But Richards argues, and I find this convincing, that Brandeis changed his mind about the relative balance between privacy and free speech. In his Whitney concurrence, which we discussed, he came to mistrust the ability of judges to decide what kind of speech was or was not in the public interest, and did not want to protect individual citizens from hateful speech, because he thought the process of collective deliberation was what made democracy possible. And in Richard's view, and again I find this persuasive, Brandeis' notion of individual self-fulfillment, making people free to develop their faculties, rooted in his love of ancient Rome and the 5th century polis, was more about having complete access to the facts so people could make up their own mind, and it was not based in the protection of dignity. And indeed, Richard says, and I think I agree, that the more mature Brandeis would not have allowed for dignitary protections.
Well, I obviously don't know the book and don't know Brandeis' background. Whitney, it seems to me, is clearly right. Whitney is a case that says when you're talking about political speech and people are speaking about things that they passionately believe in, it would be a terrible suppression of human dignity to call certain ideas out of bounds and not allow people to express them. But I'll throw back a hypo that helps me think about this. I had just left ACLU. I just ceased being legal director when the Skokie issue broke. And what little influence I had inside the organization at that time, I threw very strongly in favor of what the ACLU did. I believe that they were right in insisting that the Nazis had a right to march, and that the country was stronger for the fact that we recognized that kind of political speech offered to the general public despite the fact that it's a Jewish suburb that they were marching in. But it was they were marching on a public street and making a statement to the general public. That hearers at that point just have to really they have to just tough it out because just because somebody's speech offends you, deeply offends you, is not a justification for shutting it down. And there, I think, whether you call it dignity or access to the facts, Brandeis's conception of the First Amendment is absolutely right. But let me flip the hypo. Suppose instead of marching down the main street of Skokie, suppose what they chose to do is have their demonstration at the funeral of one of the survivors of Auschwitz, who's being buried in Skokie, and they decide they're going to have their demonstration there. I think the scales change at that point. I think the hearer's right to be able to be free from this for at least the period of time needed to inter the deceit with dignity and without having to deal with somebody else's insistence that they're going to intrude on that ceremony. I think that's right. I don't think it's possible to simply say the hearer always wins. That the speaker always wins, just like I don't think it's right in law to say that the hearer usually wins. I think it's much harder, and that what we need is a commitment to some sort of balance between the two that won't turn what is an excruciatingly hard question into an automatic easy one.
One more beat on this because it's interesting and important, and also seems I want to ask you, where do you extract a protection for dignity from the text and structure of the First Amendment? Brandeis, in his famous article, acknowledged that our law, unlike European law, does not protect against offenses against honor. And he had to propose an entirely new tort, and the text doesn't seem to cover it.
Yeah, I don't find it in the text. When I discuss dignity in my book, I discuss it as part of the three usual justifications for a robust free speech clause that are given. The three usual justifications are Holmes's commitment to the marketplace of ideas, Brandeis's commitment to the dignity of the individual, and the modern, almost obsessive fear of government getting its hands on communications process. And it's the combination of those three ideas that leads people to say we should have a robust First Amendment. Don't forget, we had a robust First Amendment only since the 1960s. For many years, those intellectual arguments failed. Now, I think as a country, thank goodness, we accepted those three intellectual arguments. And thank goodness we have a strong, robust First Amendment now. My plea is to go back and then say, now, wait a minute. Those are all interesting arguments. Marketplace is interesting, dignity is interesting, fear of government is interesting, but come back with me to the text. Come back with me to the 6 ideas of the First Amendment and tell me what you think free speech ought to look like in a text committed to having a strong egalitarian democracy function. Tell me what you think the press clause should look like. I mean, the great indictment, the way the court reads the free speech clause now, is they have taken the free speech clause. They've taken the 10 words of the free speech clause. Congress shall make no law abridging the freedom of speech. They have taken 3 words out, the freedom of. And they read it as Congress shall make no law abridging speech. Now that's a very powerful idea, and thank goodness for it most of the time. But as you see right now, it's a rootless idea. It's not bounded by anything. It's not linked to anything. And I'm trying to say, link it to something. Link it to the text. The full text says the speech clause is an important component. And what they've done is they've taken the speech clause and they've turned it into an imperial free speech clause. The free speech clause has completely conquered the press clause. There is no press clause. The speech clause does all the work. The speech clause has wiped out the petition clause. The court has explicitly said that the petition is nothing more than just a speech. The assembly clause is virtually toothless because they view it as a kind of speech minus that isn't really terribly protected. And they've even now, in the last couple of years, begun to use the First Amendment as a way to say when there's a violation of the conscience clauses. And so what you have are these 7 words conquering the entire First Amendment. And my plea is to go back and say, what would a free press look like in a robust democracy? What is the role of a free press in a robust democracy? That's how you construe the free press clause. What's the role of assembly in a robust democracy? That's the way you construe the assembly clause. And just like Harlan found the 7th non-textual idea in the First Amendment when he essentially invented freedom of association in 1958, which has now become one of the most important rights in the amendment. Just as Harlan found the 7th, there's more. There's a right to vote in that amendment. Because it is the logical denouement of the textual amendments is a right to express yourself in connection with the voting that makes the democracy work. Now, do I think this is consistent with some idea that the founders had? No, I don't. I'll confess to you now. I'm not particularly interested in what dead white men who owned slaves thought. They were magnificent for their time. They were radicals. They saw things that transcended the limits of their time. But we all live in a parenthesis. We all live in a parenthesis that limits our capacity for imagination. And the founders, brilliant as they were, did not have the capacity to foresee everything. That's why Madison put a 9th Amendment in there. Madison's 9th Amendment is an invitation to expand rights when necessary, using a disciplined process of analogy, exactly what Harlan did in finding freedom of association. We shouldn't be afraid to do that with the rest of the First Amendment, and we can rescue democracy from what is today. I mean, I call American, since Baker versus Carr, it's now more than almost 16 years. Since Baker versus Carr, the courts have essentially shaped American democracy, and they've shaped it doctrinally. They decided federalism cases, they never decide a democracy case. And it's like an architect who builds this beautiful house, and it has windows, it has stairs, and it has walls. Unfortunately, the windows don't open anywhere, the stairs don't go anywhere, and the architect is then stunned that nobody wants to live in his house. And the truth is, the Supreme Court has built us a democracy in which the windows don't open and the stairs don't go anywhere. And you know what? Many people feel awkward living in it because it is not the democracy that the First Amendment, I think, aspires to. And I'll connect it to where Jeffrey went. Aspiration is true. What I'm trying to do is complete the liberty's aspiration project by rooting it in text, by rooting it in a textual approach to the First Amendment that says, confront these words, confront the order of these words, confront the text as some evidence of what Madison thought. I don't know what Madison thought. But confront the text itself and say to yourself, what is it? It's a gift to us. Those 6, I assure you, you can go back and test me on history. Madison had 42 source documents, starting with the Magna Carta. He had 42 source documents to work with. The Magna Carta, the 4 English Bills of Rights, the revolutionary, the colonial charters, and the revolutionary constitutions. And he went through every single one of them very carefully. Not one of them has these 6 rights in the same place, much less in this order. This is a unique placement of words in the history of our culture. It seems to me to be wasted by tearing an occasional word out of the text, holding it in our hands, and thinking that we're really figuring out what it means. And so my plea is, when you go home today, take your First Amendment out. Maybe take your whole Bill of Rights out. It would be nice. Give it an airing.
see sort of particularly some of the First Amendment interests getting carried out. But where, if at all, if you think that there is sort of a special place for expert speech, which there might not be, but how that would be carried out, sort of whose interest, there might be multiple interests at play, and does it kind of fit into the dignitary concept or a different one?
Well, I think it's a nice question, and I confess not to have thought about it very much, and I should. To the extent that I've thought about it at all, I've always assumed that free speech is contextual, that there's no such thing as a single free speech clause. There's free speech in my classroom, there's free speech in this room, there's free speech on the streets, there's free speech during an election campaign. By definition, it's contextual because the context is what tells you what the government interests are in either regulating it or not. And I've always thought that academic freedom was the place that I thought expert speech went, and that there's a special protection for academic freedom. There should be a special protection for academic freedom as part of this idea that is consistent with the idea about Brandeis, that making people aware of every possible fact, every possible nuance before they have to make decisions about either political or social decisions is crucial to the functioning of what I consider to be the Madisonian First Amendment. Mm-hmm. So I would give a great deal of protection to protected speech.
Great. Closer to the back where we were starting off.
Oh, no, sure.
Or you can also hand around the mic as you like.
Give me a workout.
Okay. Yes, exactly. Stairmaster time.
Hi, thank you very much for that. I guess since it didn't come up during the conversation, I feel I must ask about how your vision of the First Amendment applies to regulation of money in politics, given Citizens United and those decisions. And then to piggyback on that, actually, since there's so much frustration in the country, at least among some of us, about the way the Supreme Court has been interpreting democracy through the First and 14th Amendments as well, that there are some movements to have constitutional amendments both for an explicit right to vote in the Constitution as well as some form of amendment that would overturn Citizens United. And so I was interested to hear how you thought of what you thought of those movements in light of your vision of democracy and what the Supreme Court currently looks like.
Let me try to answer that in two parts. The first part is, how would my formulation interact with the existing law of campaign finance reform? It would completely overturn it, I hope. In fact, Jeff knows this because I've been thinking about this for years and he knows it. What drove me into the book was the frustration with the Supreme Court's campaign finance rules. Now, I have to tell you, this is I have to confess to this. I signed the brief in Buckley as an ACLU lawyer, and so I thought then that, and I actually think that Buckley was right on its facts, because the amounts that were permitted under that set of regulations were so low that they would starve the democratic process of any real chance of robust campaigns. And I have no problem in saying that I'm nervous enough about incumbents passing laws to keep themselves into power, that I think courts should and must look at any law that gets passed that way and make sure that it allows the avenues of robust opposition to develop in a way that will maintain strong contested elections. So I actually thought, I had no trouble signing the Buckley brief because I thought the Buckley statute was unconstitutionally narrow. It starved the process. But that's not the same thing as saying there's no limit. That just because you say the limit can't be too low, it doesn't mean that the sky is the limit. And I actually think, this is not original with me. It's Stevens' position, and it was the position of both Skelly Wright and Spotswood Robinson in those years. I think the court made a dreadful mistake in equating the spending of money with speech on a one-to-one basis. There is a link. And it means that you can't cut the money out to the extent that it absolutely makes the speech meaningless and not strong enough to have a vigorous election. But saying that doesn't mean that there's no limit. There's no point at which the spending of money stops being speech and starts being power. It starts buying a megaphone bigger than anybody else's, ramming your message through just because you have money in ways that other people don't. I thought that they made a terrible mistake in Buckley on that, and I don't think our democracy has recovered from it. The second bad mistake in Buckley was to say that political equality is not a compelling interest that would justify regulating spending at obscenely high levels. And it seems to me that the idea of one person, one vote is gone. We have a system here called $1, one vote. And that's our system. That's the reality of our political system. We have formal equality and substantive inequality. And there's a word for that, and it's called hypocrisy. And it seems to me that we backed into it through the campaign finance cases. All the campaign finance cases after Buckley are all predictable, because what Buckley does is build an airless box within which reformers will live and die. Because unless you break the box and change the Buckley case, the problem is not Citizens United. Citizens United made things worse by opening up the coffers of corporations and pouring even more money into a system that was already groaning under the imbalance of big money. But if we got rid of Citizens United tomorrow, it wouldn't fix the system, because you would still have a huge imbalance where individuals are going to do it. And I'm not talking about Republicans or Democrats. I'm talking about rich and people who are not rich. It doesn't calm me down to think that for every Koch brothers, there's going to be somebody on the left who'll spend money as well. Because guess what? They're ultimately united by a vision that has us talking about estate taxes much more than talking about aid to the poor. And the truth of the matter is that unless you make it possible for ordinary folks to be able to at least help shape the agenda of their democracy, you're not going to get a functioning democracy. And so that's why I urge you to think about the First Amendment as a blueprint for a functioning democracy. Now, that doesn't mean my idea of what I did a session with Justice Sotomayor on Friday, and she asked me a fabulous question in the middle of this. She said, well, what makes you think, Burt, that you know what the best democracy is? And I said, well, it's because I have tenure. And she laughed and she said, yeah, but I have something else. And so she was making the point that somebody, it doesn't help, it doesn't end the discussion simply to say that the First Amendment's about democracy. Then you have to have hard questions about what's the best way of organizing a democracy. And it's entirely possible that the court will at the end say the best way of organizing a democracy is to let the rich spend as much as they want. Because any other way is too dangerous and is not useful. That could happen. I doubt it will happen. I mean, once the debate is defined by what's best for democracy, my sense is that we're in much better shape than having the debate shaped by 7 words pulled out of a text, where nobody thinks about democracy. But I can't say for sure that if we launch an idea tomorrow about the Supreme Court deciding what's good for democracy, I can't promise you anything would change, although I suspect important things would.
1 or 2 more questions. Yes, in white sweater, right down here.
I have 3 concerns that have evolved and emerged. 1, free speech zones.
Free speech.
Zones. In other words, at the conventions, they had zones where people supposedly could exercise their free speech versus other areas, public areas, where they could not. The second is what seems to be the right of a judge to decide what a defendant can and cannot present to the jury. Where did that emerge in Tim DeChristopher's case? He was restricted about saying he did have the money to purchase those lands, and the government rejected it. That was denied. Jury nullification is also not mentioned. And my last concern is, where do checks and balances and separation of powers fit in? I'm seeing among local governments, at least, and state governments to a further extent, where they will put separation of powers in stone and absolutely ignore their checks and balances obligations. And how can we reconcile these?
Okay, nice. Three nice questions. The first one, I have no quarrel with. The first one is already the law in many places. Given the realities of modern life, when I take the Amtrak back up tonight to New York, there's a quiet car. In that quiet car, you don't have a First Amendment right to talk on your cell phone, nor do you have a First Amendment right to look at your video games and have the sound disturb someone else. In most thoughtfully laid out urban parks now, there are areas that are off limits. If you want to go and meditate, if you just want to go and think, okay. Try giving a speech in a library. You're not allowed. We already have zones. I mean, we already know that the First Amendment is contextual. The joke I always give this way said, if I had a really rich person in my class, and that person came up to me and said, look, Professor Neuborne, I really want to do well on the exam, and I'm going to study as hard as I can for it. But what I would like to do is purchase more time. I would like, instead of having 4 hours to finish the exam like everybody else, I'm willing to donate a building if I can have 8 hours. I throw them out, right? I mean, because you don't buy time, and supposedly you don't buy time before a jury. The rich lawyer doesn't say to the judge, I'll pay 2/3 of the cost of this case. I would like to have 2/3 of the time speaking to the jury. We understand that there are many settings in which it's necessary to limit the strong speaker in order to make the system work right. Now, the jury is one of those areas. So it doesn't trouble me one bit that there are rules of evidence that limit and control the way you talk to a jury, because otherwise the courtroom would become a cacophonous place where the jury couldn't really carry out its responsibilities. Now, we can have a good debate about whether the rules are right. Maybe the evidence rules were wrong in that case, but the existence of the evidence rules, I think, are very important, and they're very important to me because that's what I teach, and I want to keep my job. But I think evidence is truly important. Now, jury nullification that you mentioned, that I don't deal with because that's maybe I should think about it as a form of expression. As a form of ultimate expression by jurors that they don't want to hear, that they don't want to comply with the law. But I'm not sure that type of what is essentially civil disobedience, I'm not sure I can fit that into my First Amendment world.
Well, in any properly functioning town hall, the one job of the moderator is to end on time. So for a superb, provocative, and democracy-promoting book, please join me in thanking Burt Neuborne.
Thank you so much.
That is a good discussion that you want to continue and have be much longer. Gosh, it just opens up so much.